Next matter to come before the court this morning is Cosari versus Cosari. Both sides will have 15 minutes to present oral argument. The appellant may reserve, up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you can let me know when you get started. I'm keeping the clock. You can also see it on the monitor over there. Could please stay behind the podium and keep your voice up. We're recording this argument today, and please do not use the names of minors or victims. You can refer to them in any other manner that makes sense, the child, the victim, however. I'm not sure that makes a whole lot of sense in this argument, but we always like to make those advisements before we get started. The judges have read your briefs. We're ready to proceed when you are. Okay? Would you like to reserve any time for rebuttal?
I would like to reserve 5 minutes.
Okay.
May it please the court, my name is Carolyn Soder of the firm of McCarthy Levitt Crystal Liffman, and I represent the appellant, Raymond Cosari, who I will refer to for identification purposes in my argument as husband. My client is appealing the January 3rd, 2022 judgment entry of the Summit County Domestic Relations Court, and the crux of his argument is that the only true judgment entry was the December 22nd, 2021 judgment entry. That was the only judgment entry which everyone agreed to and which everyone authorized signatures for. My client has presented 2 errors for this court, the first being that the trial court had erred in adopting that so-called corrected judgment entry when husband had objected nearly immediately through a filing on the docket noting his brief in opposition. The judgment entry was adopted so quickly by the trial court, likely only due to the electronic signature that appeared on that so-called corrected document, reflecting the authorization of counsel when such authorization was never provided. The fact that, and I'm referring to myself as counsel, the fact that my electronic signature was unauthorized on that so-called judgment entry is not disputed, and it's apparent from the filings. The court declined to rule on that brief in opposition and seems to have outright ignored it in adopting this corrected entry. And the reason for that appears to only be that counsel's signature appeared on both versions of that judgment entry, but only one signature was authorized, and that was for the December 22nd, 2021 judgment entry.
Can you go back? You say a brief in opposition. So after I think it was January 3rd that the
Yes.
order was filed, the order that purported to be an agreed entry that was not an agreed entry.
Yeah. Yes.
Did you file a brief in opposition to that?
There was a brief in opposition that was filed nearly immediately, and that's reflected on the docket as a part of the record.
What day was that filed?
I believe that brief in opposition was filed the day following the submission of that.
And then, as I recall, at maybe January 6th, if I'm recalling the dates, counsel for App.No filed what I think she termed a vote to clarify the record, that in fact you had not agreed to that.
She filed a notice of mistake.
Something
Yes.
that we called it, attempting to clarify the record, you had not agreed to that.
Yes.
And your appeal was filed right about that same time. Is that correct?
That is correct, yes.
Did the trial court ever made any ruling about the notion, the note to clarify, or whatever we're calling it? Was there any other subsequent rulings from the trial court, or did the trial court feel that jurisdiction had been diverted because you filed your?
The trial court had not done anything. They did not rule on that, the notice of mistake. The one thing that the trial court did do, there was that motion for 60A hearing that was filed by opposing counsel. The court believed it was divested of jurisdiction in relation to that one issue. The other issues were not discussed with the trial court.
Did the trial court, and I'm sorry, I'm not understanding, did the trial court make any subsequent ruling on that 60A, have any hearing?
No.
Other than the January 3rd order that was signed?
No, the court did not. And the sequence of events was very much the judgment entry that everyone agreed to was submitted. That should have ended the matter. Then the corrected order was submitted, and that was submitted as a proposal to the court. The court then adopted that proposal, and presumably because both signatures appeared. And they did that without ruling on the brief in opposition, presumably again because both signatures were on that document. And my client is truly trying to get back to the concept of if you signed it and submitted it, it is a judgment entry. That was the settlement. You can't go back and then change the settlement because your client was upset or didn't read it or didn't fully understand it. If we allowed for that kind of clawback, everyone in domestic relations would do it.
So we have the agreed entry that was filed and signed in December by both parties, and we agree that was signed by both parties.
Yes.
Was the transcript from that hearing where that agreed entry was put on the record, was that ever submitted with the trial, to the trial court?
No, the transcript was, the parties spoke on the record about the content of their agreement, and then both counsel didn't dispute the terms and submitted an agreed judgment entry, so there was no need to subsequently submit the transcript to the court because no one was alleging that something was different from the document that was submitted on December 22nd.
Can you tell me the remedy? It may seem obvious, but can you tell me the remedy that your client is seeking at the Court of Appeals? Is it a vacation of the?
Yes, to vacate the January 3rd judgment entry and restore the December 22nd, 2021 judgment entry.
Thank you.
Are there any other questions I can answer for the court?
I guess your assignment order number 2 is somewhat confusing to me, as I read. Did they ever set a 60-day motion for hearing?
They did.
Okay.
They set it for hearing, and then the court believed it was divested of jurisdiction because of the pending appeal.
So you're saying they abused discretion once the motion was filed, even setting a hearing, they should have just denied it sua sponte without a hearing?
They should have denied. So the thing that's really confusing about what the trial court did is the trial court had an entry in place. They have this December 22nd entry. Then the trial court subsequently has a January 3rd entry, and it makes no sense when the matter was concluded by each entry, why, and especially that January 3rd, if we follow the court's reasoning of January 3rd being the final order, then the court never should have set a 60-day hearing to begin with, because all matters would have been resolved. There wasn't any motion pending. So it's a very confusing way that the court went through and
If we were to
scheduled
vacate
hearings.
the order from January 3rd, we would still have a pending 60A motion on whether or not it was or was not a clerical error that would need to be heard by the court.
That is true. That is true. It's just that if the court stood by January 3rd, there's no reason to have a 60A, but if we restore the 1222 entry, then that 60A motion would still be pending.
Pending for the court
Yes.
to decide whether there was merit in it or not.
Yes, that is correct.
Seeing no other questions, you may continue, or you have 5 minutes for rebuttal.
I'll reserve my 5 minutes. Thank you.
Sure.
May it please the court. My name is Leslie Gransky, and I am here on behalf of Brandy Cosari in this matter. This boils down fairly simply. I made a mistake. my office made a mistake, which means I made a mistake, and we submitted an order bearing an approval that wasn't given. And we immediately notified the court when we discerned that that had happened. If this court reverses the entry granting the 60A relief, then we're back to hearing the 60A relief. And then maybe the court could look at the transcript. However, it is incumbent on an appellant in this court to show that the ultimate order issued by the trial court is in error. And, Your Honor, you raised the perfect question. Where is the transcript of the November hearing where it was read on the record?
Well, I appreciate your candor, both the trial court below and here, that there was a mistake made by your office. I appreciate that. It seems to me that perhaps that mistake leads us to not have a transcript. Had we gone through the process, we would have granted it. We would have had a hearing transcript typed up. We would have been able to look at it and see what was said at the hearing when the agreement was read on the record, and we'd be in that position.
And the burden is on the appellant to show that the order that was signed by the Court of Appeals, trial court, which I didn't mean to have happen, but it happened. Now, this court's review was that error? Does the record show that was error? Actually, no. Because the party's agreement, which was read into the record, is not part of the record. It was not ordered. It could have been ordered as part of the appeal here. It could have been transcribed. But we don't know in the record what happened at that hearing. If this goes back to the trial court, I will be able to present what happened at that hearing, and then the court can determine whether the agreement that was reached in December accurately reflects what was said on the record in November. I know that sounds like kind of circuitous, but it is. How do you know that the trial court, taking my error aside, let's say I didn't accidentally approve counsel's signature. If the court signed that and there was an appeal, there'd be nothing to prove that the court had erred. I filed 2 motions to remand in this court just to send it back and do it right and get the transcript. But the fact is that if this court wants to rule on what happened in that January entry, there is nothing in the record to show that was wrong. Wife said one thing, husband said another thing in pleading, but the transcript says what they agreed to, and that's not true. So what do? We presume that the trial court did the right thing.
Well, counsel, as it relates to the first assignment of error, the argument is not what it says in the entry, but that it was error to enter an order.
Right.
So can the Court of Appeals simply say it was error to enter that order?
I think a court can rule on conflicting motions without having a hearing, and so it could issue an order. You know, but I'm the stumbling block there, but I think the court could have ruled on those 2, the motion and the response. And essentially that's what it did.
But unfortunately, with it, you said, to be fair, incorrect information at the time that this was an agreed entry by both parties and not anything.
Absolutely. There's no issue. So I think the court could have issued a ruling. I think it should have done what it did, which was it scheduled it for a hearing in February.
But then they would have, if the court issued this ruling within 3 days of that motion being filed, they probably would not have complied with the local rule to make
That's
sure.
true. That's all true.
To make sure responses were filed and
You know,
everything.
but the court set it for a hearing because that's what the court does with motions. It's it for a hearing. And I asked the court to remand it to the trial court so we could go there and presumably get that transcript and have the court review it.
So with the electronic filing, was the order that was filed in error, was that attached to the, is that on a docket entry attached to the motion?
You don't see it.
You don't see it?
We don't have a notice of submission of proposed order provision. Some counties do, not some counties.
Okay.
So
Interesting.
I wish we could have remanded this a year or two ago, and we could have gone forward with the 60A, and we could have had a proper hearing, and you would have a proper record before you, but that's not what happened. And as it stands, although the local rules would have said this was an early ruling, but we would have the substantive transcript before us.
Well, we also have remaining, without the transcript, the argument of the appellant, which was there was no way, motion notwithstanding, being filed notwithstanding, okay? There was no way that that order, agreed or not agreed, should have made it onto the court's docket.
Well, an agreed order could have made it to the docket, obviously, both parties agreed that that was a problem, and they agreed to fix it. That could have been filed in court. Am I misunderstanding your question?
No, but when there's a motion pending, was it a request for a non-proton order?
No, it was a 60A, it was a clerical error. I believe that's what it was. The terms are consistent in everything, and then there's one hiccup, and it was not what they agreed to. I can't prove that, but it's not my burden to prove that what the trial court ultimately did was wrong. I tried everything I could do to get the trial court to hear it, but it wouldn't because there was an appeal pending. And so all of this time and all of this travail and all of this effort, I'm not talking about what happened in mediation, but there were more than 4 hours of mediation session, could have been avoided by just letting us go back to the trial court and let them look at the 60A.
In so doing, then, the appellant would have waived the argument. I mean, the request for remand is a request to dial back time. But doesn't the appellant still have an argument that it was incorrect for the trial court to enter that order? Notwithstanding the merits.
Right. It seemed appropriate to let the court hear it on the merits, analogous to a 60B motion, and avoid all of what we are doing now. And it could have been heard on the merits. The substance of the parties' agreement could be compared to the December order.
Thank you. You have a little over 6 minutes if you want to continue, or?
No, I believe that you could affirm the trial court because the record doesn't reflect that what the trial court did was error, even though it was done incorrectly. It was done incorrectly, but prejudicial error is something that has meaning, and if you demonstrate that an agreement was this and that's not what the order says, you win. But if you don't have that demonstration of what the agreement was, then this court has nothing to review against that order, which was erroneously submitted as authorized. Hard cases make bad law, but if this court reverses the trial court, then we have a 60A, and we can hear that. I don't think that's an inappropriate way to deal with this. I appreciate your attention. Thank you very much.
Thank you, Councilor.
In response to Appellee's argument, where we should be starting from is, if we go back to the trial court, is with 12/22/21 being the final order. And then it would be Appellee's burden, wife's burden in the trial court to try to change that, rather than my client trying to change the January 3rd of 22 order that never should have been entered to begin with. It's inequitable for my client to have to be in the position of looking to change that January 3rd order that should have been vacated to begin with. It should have been vacated to begin with. This all could have been avoided had council agreed to vacate that January 3rd order and go back to 12/22/21, which is where we should be. That's the crux of the appeal. We should just be at that December 22nd of 2021 order. And the whole argument about that there isn't a transcript, I agree with Judge Stevens saying, there's not a transcript because of the way that this went down. The matter doesn't really concern transcripts. It concerns the filings, the signatures, and then subsequent buyer's remorse in an attempt to claw that back. And it's simply this, that the settlement was reduced to a judgment entry. Everyone approved that judgment entry, affixed electronic signatures to it, and it was submitted and became that December 22nd of 21 judgment entry. Wife presumably then had some buyer's remorse, tries to claw it back, alleges an error to a deliberately negotiated term of 50-50, and then this purported corrected judgment entry was submitted to the court and adopted because it erroneously bore both counsel's signatures. The only judgment entry in this case is that December 22nd of 2021 judgment entry. The January 3rd of 2022 judgment entry should be vacated. This is, everyone should have an expectation that when they sign a judgment entry and they submit it, that's the end. It shouldn't be, well, actually.
It remains to be determined by the trial court under your theory that they need to look at this and determine whether or not it was a scrivener's error, or they on the record said we agree to, I think if you want to say they agreed to 50-50 and as opposed to 70-30, that's what your client is proposing. I take it from the argument.
That's true.
They agreed to equally share, but that's for the trial court to determine.
That would
In
be
your view, what your argument would be, they should listen and hear that. And that's never been done yet.
That has not been done. But the position of unfairness would be for that January 3rd order to stand and for the error to remain in place when December 22nd was the only true agreement and the only true judgment entry that should be reflected on the docket. That should be the final order. And if a counsel for the appellee wants to change that in the trial court or argue it, that's her burden. Right now, the way that the judgment entries were issued, it becomes my client's burden to try to go back to the only true judgment entry of December 22nd of 21. So what we're asking this appellate court to do is vacate January 3rd, go back to December 22nd, and then the trial court could listen to the arguments, hold a hearing if they
Out of
wish.
curiosity, when appellant seemed to assert that she asked the matter to be remanded for proceedings at the trial court level, did you object to that? Or
I did object to it because that would effectively turn back the clock, and the issue would still be that the January 3rd order is the order, and my client would be trying to change everything and go back to December 22nd. That shouldn't be his burden. It should be their burden, the appellee's burden, wife's burden, to try to change December 22nd. We should be in that position, not in the position of January 3rd.
So you would have agreed with the remand that said, dispose of the January 3rd hearing and go back and hear the 60A motion on the December 22nd decision that was made, whatever date that was.
If the court would vacate January 3rd and restore December 22nd, then I would agree that the trial court could, in its discretion, hold a hearing on 60A.
60A has to do with clerical error. Do you think this is a clerical error?
Absolutely not, which is the reason for the second assignment of error that I did submit. I don't think that this is a clerical error. Clerical error would be something akin to misspelling a name, calling someone the plaintiff when in fact they were the defendant, maybe writing in the wrong number for part of the case number, and those would be clerical errors. It's hard to imagine that when counsel writes the judgment entry themselves, that counsel would, would trip over the keyboard to the extent that 70-30 and 50-50 were reflected. It doesn't make sense, it's not a clerical error.
And council, I'll let you go over a little bit of time to
Oh,
answer
sorry.
Judge Land. No, that's fine, because you had a question before you, but I need to tell you that you've utilized your
Thank
time
you.
for today. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we've mailed to all parties to this appeal, as well as posted on the House Supreme Court website. Thank you.